My name is Michael Young, and I'm a lawyer who handles will contests throughout the state of Texas. A common question that I get is, what's the difference between expert testimony and lay testimony? And that's often an important issue in a will contest, and I'll explain why. For testamentary capacity, you're inquiring into the mental state of the testator. Did they have the mental capacity to understand what they were doing when they made a will? And Texas has a test that essentially is, did they understand the nature of their bounty, which is essentially their next of kin? Did they understand the nature of their assets? And could they keep in their mind the thoughts, their recollections of their kin and their knowledge of their assets? Could they keep it in their mind long enough to formulate an estate plan? And, on some level, that's not real complicated. We should know who our relatives are. But for someone facing severe mental problems, it may not be. And when you discuss a complex estate that may involve many land interests, mineral interests, numerous accounts, well, it can take a relatively sophisticated level of mental capacity to really understand what you have and what you want to do with it. Well, that comes into the issue of evidence. Well, who or what provides the evidence of mental capacity? Well, sometimes it's medical records. And when you're dealing with medical records, generally Texas courts do not allow a layperson, a friend or a spouse or a child of the decedent, to just throw a bunch of medical records in front of a jury and explain to them what that means, because that's not generally within the knowledge of lay people. It's usually doctors. And in these cases, it may even be forensic psychiatrists who are trained to evaluate mental capacity, either through examinations or in reviewing medical records. That testimony is considered expert testimony. A forensic psychiatrist or psychologist, for an example, they generally would not have any personal knowledge. They would not necessarily have examined the testator. They would have no personal knowledge of their assets, how they interacted with people around the time of the will. So they can't testify directly, but they do have the education, the experience, the demonstrated skills to evaluate, often through medical records, and give an opinion to a jury about mental capacity, whether they had the necessary testamentary capacity to execute a valid will. That's expert testimony. On the same issue, non-expert or lay testimony would be people who regularly dealt with the testator, friends, acquaintances, family members, business associates, the secretary at the doctor's office or the teller at the bank, who could testify about the person's condition, say, in the years before when they made the will versus when they made the will itself. And if they could offer evidence that the person didn't recognize them, couldn't count money, didn't know what assets they had. Or conversely, they can say, yeah, I dealt with her regularly during that time period of the will, and they were able to carry on a very intelligent conversation, and they seemed to possess the mental capacity to understand the nature of their business and what they were doing. I understand this is a complex topic, but it's a common question that I have, and I hope this video has helped you understand the difference between lay and expert witnesses in a will contest.